Good afternoon, everybody, and welcome to all of you to this Bonavero discussion group on corporate human rights due diligence in practice. My name is Anneli Mikus. I'm the head of programs of the Bonavero Institute of Human Rights at the University of Oxford. It has really been an exciting few weeks in the field of business human rights, with several important court decisions against Shell in the UK and Netherlands, as well as Total in France, and with some exciting legislative developments, such as the EU initiative for mandatory human rights due diligence, and also recently a proposed German supply chain law. There really couldn't be a better moment for today's Bonavero discussion group, where we want to discuss how corporate human rights due diligence should be designed to achieve real change, and also where we will consider a concrete case to think about how this can work in practice. I'm particularly delighted to have two of our Bonavero Advisory Council members with us for this timely discussion, Alejandra Ancheita and Miriam Sage-Maas. Alejandra Ancheita is the founder and executive director of the Economic, Social and Cultural Rights Project, ProDESC, based in Mexico City. Since founding ProDESC in 2005, Alejandra and her team have run strategic campaigns aimed to protect the economic, social and cultural rights of Mexico's most marginalized people. ProDESC's work is guided by Alejandra's innovative vision of an integrated approach, which combines community education and organizing, corporate research, human rights litigation, and policy advocacy, thereby bringing real structural change. It is really great to have you here, Alejandra. Dr. Miriam Sage-Maas is a German lawyer and the Vice Legal Director of the European Center for Constitutional and Human Rights, ECCHR, where she has built up the Business and Human Rights Program. In collaboration with partners worldwide, Miriam has brought several groundbreaking cases against corporations for human rights violations, both under civil and criminal law. Miriam is also a lecturer at the Freie Universität Berlin. Really good to have you with us, Miriam. A very warm welcome also to Professor Surya Deva, who has kindly agreed to give a response to today's presentations. Professor Surya Deva is an associate professor at the School of Law of the City University, Hong Kong, and the current vice chair of the UN Working Group on Business and Human Rights. This is in-depth international perspective on developments in the field of human rights. There really couldn't be a better respondent. Thank you so much for joining us. First, Alejandra and Miriam will present the Unión Hidalgo case against Électricité de France, which ProDESC and ECCHR filed jointly with representatives of the indigenous community Unión Hidalgo last October under the French law de vigilance. And Surya Deva will comment on the case. We will then turn to questions from the audience. We are in a webinar format, so please put your questions in the Q&A window, and I will then moderate the questions to our speakers. Please note that we will record the seminar and it will be online available shortly after the event. And with that, I will now hand over to Alejandra to share with us some more information on the Unión Hidalgo case. Alejandra.
Thank you, Annelien. Good afternoon for everybody, and good morning for other people that probably is also joining the webinar. First, I would like to thank the Bonavero Institute of Human Rights for the invitation. And as Annelien also say, I have the honor to collaborate with the Bonavero Institute of Human Rights. And I'm very proud of the work that the Institute is already doing. And as you know, this COVID world requires us to be more focused on human rights in a transnational level and in finding different ways to keep connected in these cases, and also to keep connected in the alternatives for the violations to human rights. I also want to thank Professor Surya Deva for providing comments, and of course to Dr. Annelien Mikus for sharing this event, as well as my colleague Miriam Sage-Maas. I think I don't going to take time to introduce myself, because Annelien did a very kind introduction about me and my work. I will talk just a little bit of ProDESC and the work that we have been doing for around 15 years, defending economic, social, and cultural rights. And we are principally focused in the defense of the right to land, territory, and natural resources of indigenous communities, but also we are working in the defense of labor rights of workers, in particular of women. And we have a comprehensive approach that take in consideration the defense of human rights through strategic litigation, strategic communication, advocacy, and research, and also supporting the internal organization of communities that are also human rights defenders. I would like to talk along my colleague Miriam Sagemas from the European Center of Constitutional and Human Rights about the transnational collaboration that we had been able to build in the defense of the community of Unión Hidalgo. In order to bring more information, concrete information about the case, I would like also to share with all of you a very short video that shows the community and the voices of some of the human rights defenders of Unión Hidalgo, and that is going to give us a frame more clear about how complicated could be this kind of cases, but also it could give us a little bit of hope that it is possible access to justice for communities around the world. So if you are so nice to show the video, thank you.
Asesoría al pueblo zapoteco en defensa de sus tierras comunales.
Identificamos como importante tener una línea dentro de nuestra defensa integral, que es la de comunicación estratégica, que busca construir una narrativa diferenciada, busca darle espacio y voz a las comunidades y los colectivos para que sean ellos y ellas mismas quienes planteen su caso hacia la opinión pública y que tengan también un espacio en el debate nacional.
Pues en un principio no podíamos ni siquiera sacar una nota, ¿no? Aquí en la región para hablar en contra de los proyectos eólicos. Las radios de la región, como los periódicos, estaban más que nada controlados por la empresa.
Vienen la gente de otro lado, viene a invertir, pero para ellos, no para la población. Entonces ellos dicen que traen empleos, traen desarrollo, pero no es cierto. No es cierto porque tenemos 3, 4 años de que están los de esta empresa acá y no se ve nada. No se hizo ninguna consulta previa. Entonces, cuando ellos ya llenen todo esto, pues no sé a dónde nos iríamos nosotros. ¿Por qué? Porque nos van a encerrar.
Gracias a ProDESC, que fueron los que ahora sí nos abrieron los ojos. Nos dijeron, estos son sus derechos. Entonces, tenemos que defenderlos, porque nadie va a venir de fuera a decir, yo lo voy a defender por ti, ¿no? Sino que tenemos que estar ahí.
Creo que defender la tierra, pues es defender la vida, ¿no? Porque significa muchas cosas, significa el mar, significa la tierra, significan las plantas, significa el aire que yo respiro, significa la amistad que he construido a lo largo de mi vida en este espacio. Desde mi visión como mujer también lo veo así. Es un espacio donde pues está la vida de toda la comunidad, y de todos los que vienen, no solamente de los que pasaron, sino los que estamos y de los que vienen todavía, ¿no?
But I hope it's a little bit just for show everybody what kind of community we are working with, and also some of the people that are really the leaders of this case. Well, As you saw in the video of Unión Hidalgo, is you can see it's an agrarian and indigenous community. Is based in the south of Mexico, and is located in the Istmo of Tehuantepec. The region of the Istmo of Tehuantepec in the Mexican state of Oaxaca is very important for wind farms. Project implementation for its excellent potential of wind resources. Almost 95% of all wind electricity in Mexico is generated in this specific region. And the region is also home of a variety of indigenous peoples who have kept their culture and languages. It is also a region with high levels of poverty, Oaxaca, Guerrero, and Chiapas, due to ongoing dispossessions of land that started during the colonial rule and continue to this very day. For us, this disposition, which is a central part of the business models, has clear winners, which are transnational corporations and specific interests within the states, and clear losers that are, of course, indigenous communities. The construction of the over 30 wind parks in the region has been highly controversial, and the promoters, the companies, and the government at the different levels have failed to address violations of economic, social, and cultural rights. The community of Unión Hidalgo has now several wind farms around its territory, and the human rights defender, Oscar Marin, said in the video, however, benefits for the community are non-existent. In the current case, the community of Unión Hidalgo is defending its land, territory, and natural resources from the French company Électricité de France, which pretends to build the biggest wind farm in Latin America named Guna Sicaru, which in Zapotec, which is the indigenous language of Unión Hidalgo, means pretty woman. During these years, we have identified at least 4 main points where the human rights on the community have been violated. The right to free, prior, and informed consent. Mexico has ratified the ILO 169 convention, and for the Mexican law, these treaties are binding. However, the Mexican authorities have provided EDF with energy permissions and other administrative procedures without the community even knowing of the existence of the project, let alone having consented to it. In a landmark resolution, ProDESC and the community managed a resolution from a Mexican judge that mandated the Mexican state to implement a free, prior, and informed consultation. However, the process has been contrary to law, and it is clear that the state and the company just want to get over the consultation to begin the construction of the wind farms. These actors even want to this day that authorities call for assemblies regardless of the COVID pandemic. This could put the community in an imminent risk considering the age of the people who live there. In a strange twist of events, the current Mexican government plans to change the law to discourage the construction of renewable energy projects due to the new national plan to strengthen the Mexican oil and electricity public companies. In the reason given by the government, however, the human rights of indigenous communities are not present, and we believe that is a huge mistake. The denial of the collective property of the land in which EDF plans to build the wind park. Most Mexican communities have a collective property of the land and not individual properties. The definition of what to do in collective lands must be decided by the community assembly. EDF has been notified by the Mexican judge of this specific characteristic of the land of Unión Hidalgo. However, they continue to act as if the land was owned by individuals, and this is done to manipulate the community and generate conflict between individuals and also is an evidence of the corporate capture of the state. The other violation of human rights is, of course, the violation of human rights defenders in the community. The state and the company have criminalized and threatened human rights defenders. The leaders of the communities can't attend the consultation assemblies without receiving threats, death threats. ProDESC and the community have documented more serious cases, for example, of kidnap attempts and specific death threats, under the false narrative that the wind park will provide progress to the community. Human rights defenders are pointed as anti-development, which then denies them of their communitarian roots of relationships. Some people even consider these human rights defenders as anti-climate change and consider that renewable energy projects must be built at any cost. Human rights defenders just ask for what is their right, a free, prior, and informed consultation and consent. The denial of any responsibility from EDF to the violation of human rights in Unión Hidalgo due to their corporate activities is the other huge violations that we were able to document and also to argue. EDF has consistently avoided any communications in good faith with the community. In the very few communications that they had, EDF has discredited community's representative and has pointed out the responsibility fall under Mexican authorities, even though they are obligated to the duty of vigilance in accordance with the French law. Unfortunately, ProDESC experience has shown that the activities that EDF has carried out in Unión Hidalgo are not one single case, but rather part of the business model that most transnational corporations have implemented during decades. This is important considering the discussions happening at the European level and in several countries in Europe and Latin America around mandatory human rights due diligence. And this is why a voluntary corporate social responsibility approach will fail to promote and defend human rights and ultimately to access to remedy should human rights violations occur. Considering the transnational character of case, a Mexican community whose rights are being violated by a French corporation, ProDESC has carried out a series of activities in Mexico to defend the community. These include strategic litigation, advocacy with the Mexican federal and local governments, strengthening, as I say, the internal life of the community and the groups of the community, and also setting a communications counter narrative to position how important it is to defend human rights. Transnational activities were also carried out, for example, with UN special rapporteurs, with possible investors of the project, and with European politicians. However, ProDESC understood that for other legal and extra-legal procedures, a counterpart in Europe was needed. And that is how the partnership with the European Center of Constitutional and Human Rights happened. I will, of course, let Miriam mention the joint specific steps taken in Europe to defend the community, not only the presentation of the litigation using the French corporate duty of vigilance law, but also our prior experience with the French national contact point. ProDESC knows the challenge of talking about renewable energies and linking this to human rights violations. That is another challenge that these communities are facing. However, rights violations do happen, and Mexico and the community of Unión Hidalgo are just an example of what is happening in other parts of the world. Renewable energy is presented as the future of mankind and intrinsically good. However, we believe that the construction of a new development model does not mean that there are people who are disposable or that have to suffer sacrifices so that everyone else can be saved. A green transition without a human rights approach can be as harmful to the communities as a fossil fuel approach, and the communities have had enough. That is another point that I would like to stress in this talk, because we have analyzed that these justifications come mostly from corporations based, of course, in the global north. Finally, I would like to say that it is a very important moment to have an impact in the discussions that are happening in Europe, but also in other countries in Latin America, related to what is the best way to build mechanisms that provide a better access to justice, and how we can transition from the social responsibility of corporations to a more clear position of corporate accountability that will give us as a society, but principally to the communities and collective of workers that are affected by these corporations, the possibility to have real remediation when these corporations are causing violations to their human rights. And in the other hand, will also send a clear message to corporations and governments related to the importance of a better preventive approach. I will leave there, and I think my colleague Miriam will complete the information about the litigation that we are now starting in the French court. Thank you so much.
Great, thank you, Alejandra, and it was really great to see the video even without sound. I think it gave an insight into the community and the human rights defenders and the hard work they're doing and the situation they're facing. And with that, over to Miriam.
Yes, thank you. Also from my side, many thanks for this invitation and this opportunity to discuss the case. Thank you so much also, Professor Suyadeva, for taking the time. I'm very much looking forward and feel very honored that we can discuss with you. Yes, this also especially timely. It's a very timely debate that we can have, as we can see, that the debates about what does human rights due diligence means for companies in different situations really is gaining more traction, at least in Europe. But I also want to probably start a little bit of explaining of how ECCHR got involved with this case and with the community Unión Hidalgo and ProDESC. So as an organization that with a legal organization with many lawyers working for it, based in Europe, based in Berlin, we do see it as our mandate to use the privileges that we have of being an organization located in the global north, but also as an organization with much legal expertise. We want to use this expertise to work together with lawyers and organizations and workers and communities that are negatively affected by the business activities of European corporations. And we do want to, and we've been doing this for the last, I would say, 12 years, that we have, we're meeting organizations in their regions. We've have regular workshops in Latin America, but also in Africa or in Asia, South Asia, and where we meet and want to hear about what are the problems that are being caused by European companies, and then to develop together with those that are really experts on the ground and that really know what the challenges are and that also know their laws and the laws that are applicable on the ground, to think about, is there a way to find legal avenues to basically bring this struggle against the corporate human rights abuses also back home to Europe. Because what you can see most of the time, and this is what ProDESC has been doing and Unión Hidalgo has been doing for the last several years, there are usually struggles ongoing in the countries themselves, and people are fighting for their rights in their courts against the direct negative effects of corporate behavior. But as economy is organized on a global scale, it is not only the actors in Mexico that are responsible and that need to be addressed and need to be held to account, but there is a large corporation in the back, and that is which is very powerful. And that is the in the specific case, the French energy company EDF. And so we do think that there is a specific. It is also specifically important to also use European courts to address the corporate responsibility of the headquarters of those companies. And I also, this case has been specifically, I think, important for us as an organization also, as I said before, that the community, together with ProDESC, have already created a very clear strategy on how they want to defend their rights in Mexico. And they have been very deliberate, and they know very well on how they want to articulate their rights in Mexican courts. And so I really felt it was a very, it was a really important experience to learn how to work really on eyes level, and then just to find an accompanying strategy now to also go to Europe and address the European actors. We have started this collaboration, I would say in 2008, like to become more concrete about it, around 2018. And back then, we clearly felt with the violations at hand, or especially with the to be feared violations, because I think this is also really important. This is finally a case that is about prevention. It's about to mainly trying to prevent the worst harm from occurring. It has not occurred yet, because normally, you know, the court cases we know happen when disaster has happened already. So at that point in time, there really was no legal venue that we could think of in France or elsewhere in Europe to say that there would be a possibility that we actually go to a court and ask for a hard law obligation to be fulfilled by the company. So this is why we decided to go for an OECD complaint. And while there was, I still believe this to this day, that we have very many good reasons to argue why the OECD guidelines are of course applicable to this thing, why there is a clear violation of the OECD guidelines, which also indicate that companies have a human rights due diligence obligation to prevent human rights risks from realizing, and if they realize the need to mitigate, and so on and so on. This OECD procedure very much failed because it showed the inability of the national contact point to actually force the company into any kind of meaningful negotiations. And I think this is also a weakness that we have been seeing time and time again. Luckily, there is the French loi de vigilance, which then went into force in 2020. And we really, we decided that this is a really an important opportunity, and that this really is a venue for the community to go to French courts now and to again argue the same, that or pretty similar to what we have already argued under the OECD guidelines, that while the obligation to ensure that that free, prior, and informed consent of indigenous communities is respected is primarily a state responsibility. We believe if you say that that equally companies have their own obligations under the have their own human rights obligations, which covers every human right that is there, then that means that also companies have a distinct obligation to find ways to operate in a way that they themselves do not infringe on the right to free, prior, informed consent, and that they do not, through their business activities, contribute to a situation where indigenous communities cannot be any more properly consulted. And so we did file, in the last fall, we filed the claim. We're currently still waiting for the court to speak about the admissibility of the case. We've also been, we will be arguing for preventative measures because we think it's exactly that we cannot wait until the consultation is finished and the land is expropriated and the wind park has started to be built. We really need the courts to make a decision now to say that EDF must halt this project until the community is properly and in freedom and in safety had the possibility to be consulted and to be heard. And until this community has made a decision that they want this, this is also, again, I think a lot of times those procedures, and I think also how companies are driving it, they're happy to have communities speak, but it also must be a consent, right? And this really, the communities not just need to be heard, but they need to say, yes, we are in favor of this project, or they can also, which means they can also say, no, we are not. So we really feel that companies, this case is about to show that companies really need to change their business strategies if we take human rights due diligence obligations seriously. I think one last word on this question. I think it's no question that we are all in favor of green energy projects and that we absolutely believe we need an energy transition. At the same time, I think also this case highlights that we need to have a just energy transition. And that means in any kind of energy transition must be taking social and economic rights of people that have usually never contributed to climate change or to the current crisis we're in, that their rights need to be equally taken seriously as any considerations on how to preserve the climate. And so we really feel like those two things cannot go separate. And so this is why it's also really not fair to start to say, well, this kind of litigation would be in any way anti-climate, climate protection. Thank you.
Great. Thanks a lot, Miriam, for explaining the legal procedures and your first attempt through the OECD and now under the Loi de Vigilance. And I think it really highlighted also the novel preventive approach, which we hope to discuss today, and I think where we can hopefully learn from also for other cases, and also for framing it within the wider discussion on climate change and environmental rights. And now I'll turn to Professor Surya Deva for your comments and thoughts. So yeah, the floor is yours.
Thank you very much, Ellen. And let me start by thanking the Bon Iver Institute for organizing this excellent webinar and also for inviting me for providing some comments. Thank you, Alejandra and Miriam, for providing very good factual situation as well as the continuing fight that has taken place in this particular case. I think this case highlights a number of issues which are not unique to this case, I will say. I will pick 5 examples of this case, and then I'm going to focus in detail only on one of those 5. So let me start with the first point I want to make. The first point is that even if there is a growing consensus that businesses have a responsibility to respect human rights, there is significant divergence in understanding what these different concepts are of development, right to land, ownership, and consent. So the corporate understanding of land is very different. They consider land to be a commodity you can buy in the market. But indigenous peoples do not consider land as a commodity. It is their mother. The issue of consent for companies is very different from the communities. And the idea of development for the governments is very different from the idea of development for communities. And that is why these communities and defenders which are protesting, they are labeled as anti-development, sometimes even anti-national and anti-climate change, as was already highlighted. This is my first point. The second issue is that the corporate capture of the state is on the face of us. It's very clear that the states are not doing what they should be doing. This is very clear. The third element I would like to highlight is, and I think the BHR scholars and the practitioners should pay great attention to this issue, that is the conflict amongst human rights, or competing rights, because rights can conflict. And under constitutional law, we have number of principles and devices to reconcile those conflict of human rights. But I think in the field of business and human rights, increasingly, we would have to apply certain rules and principles and approaches where we can strike a balance when the rights of one person may conflict with a competing human right, or at least a legal right of another person. So I think those are the issues that needs consideration. The fourth dimension this case highlights is lack of corporate accountability. The struggle continues, like the NCP complaint was made, but no success. And then the case is going on before the French court. But I think it is too early to say that the corporate accountability will result from this litigation. I very much hope it happens, but we cannot take it for granted that this will happen. We can also not assume that in every case, there will be someone like Miriam, Alejandra fighting this much. There are thousands of such cases happening all over the world. And my last point is that this case is a classic example of how not to do human rights due diligence. The company claims they have done the due diligence well, but I think the communities are not satisfied with it. And I think this shows how this could become a problematic exercise. And I would like to address now on this last point, human rights due diligence, because this is the lingua franca. This is perhaps the most exciting aspect of the business and human rights field in the last 10 years or so after the UN guiding principles. And because in the European Union, in Germany, in several other countries, there's a lot of focus on mandatory human rights due diligence. Let me raise some red flags for your consideration. Because I have written critically in the past that certain things will not work. And let me dare to say now that mandatory human rights due diligence will not work if we don't get it right. And I would like to caution against what I will say 3 sets of issues: conceptual issues, operational issues, and structural issues. Or we can say these are 3 folds of limitations: conceptual, operational, and structural. And my comments are flowing from this case, of course, but they have wider implications for everything that is being discussed and debated in different jurisdictions about human rights due diligence or mandatory human rights due diligence. My first point is that due diligence is about a process. And we should not confuse this with the outcome. Because in most of the cases, the obligation that is being imposed on businesses is the obligation of means. It is not an obligation of result. So it is quite possible that in many cases, businesses may be able to satisfy these legislation and still there will be human rights violations. And I think that is a conceptual difficulty in my view with the human rights due diligence. The other issue is that if you look at Pillar 2, it was not meant to be legally binding. Pillar 2 is not ready to be cut and paste into a legislative framework because it is vague, it is very wide, it is highly ambitious, that you cannot just copy and paste Pillar 2 and make it as legally binding, in my view, either in a domestic law or in the international instrument. So I think that issue has to be further clarified. The related issue is that access to remedy is not part of due diligence. It is part of Pillar 2. It is part of Pillar 3. And when one can argue it is part of Pillar 1 as well. But access to remedy and corporate accountability is not part of human rights due diligence. And there is a danger that if states enact these legislation without providing for access to remedy and corporate accountability, it will be a partial or half-baked solution to this issue. Now let me move on very quickly to the operational challenges or operational shortcomings of due diligence. Here I would like to highlight 3 things again. First of all, there is a significant outsourcing of duties or responsibility by the state and by businesses. So who should be doing human rights due diligence? should a state have a role in supervising and monitoring? And they hardly do that. In most of the cases, they outsource this obligation. In many cases, even businesses are not doing it on their own. They outsource it to a consultant firm. So this outsourcing is highly problematic. The second issue is that whatever communities say, it always been yes. So communities say, we don't want this project. So no from community means yes. Maybe means yes. And of course, yes means yes. So in this situation where everything means yes and the project has to go ahead, what does it mean to have this process of human rights due diligence? This is a question that we need to ask. The other issue that was not, I think, highlighted, but if you look at in the written document, it is provided, businesses often divide communities. Or sometimes communities are divided on their own, whether to have this project or not, and businesses exploit those divisions. Rather than building a consensus, they exploit those divisions and say, oh, we have the consent from X percentage of community members. And of course, all of us know very well that due diligence is done at a very late stage, which basically means that withdrawing from the project is not really an option in terms of prevention in many cases, which is problematic. Now, let me finally talk about structural limitations of this concept. And again, I would give 3 examples of these structural limitations of human rights due diligence. And this may disappoint many people in this webinar who are great admirers of human rights due diligence. Like, I personally see this concept has a value, but it has significant limitations. We should not expect that due diligence is likely to address root causes or root challenges in the business and human rights field. The issues about inequality, poverty, and significant issues about climate change, gender discrimination that we are experiencing, I very much doubt, to be honest, whether due diligence could overcome all the challenges, the structural, the fundamental challenges that we are grappling with. Secondly, due diligence, the way it has been practiced so far, it does not address the asymmetries of power, the unequal arms between businesses and communities, between government of one country, between the government of another country. It also does not address the issue of corporate capture. Rather, I would argue it promotes corporate capture because states see businesses integral, they're part of a solution. So states are going hand in hand with businesses and corporate interest when it comes to due diligence. And my last point is about polycentric governance. Now, the polycentric governance, the idea was that we cannot really rely on states. They cannot be trusted. They cannot on their own fix the governance challenges. And I agree with that. But are we coming to square one? Because we are expecting France, Netherlands, Germany, European Union to enact mandatory human rights due diligence legislation. Does it mean that the polycentric governance cannot really overcome the fundamental and the basic issues about the state governance? So we still need states. You cannot escape from those challenges by merely talking about polycentric governance. Thank you very much.
Thank you so much, Surya, for those thought-provoking ideas and questions you raised, really thinking about the structural difficulties. So I think that's really lots of food for thought, and I'll probably turn over to Alejandra and Miriam for their responses before opening the floor to questions from the audience. But please do keep your questions going in the Q&A window. Alejandra, Miriam, who wants to go first? Miriam, do you want to start?
Yes, I can go. Well, thank you, Surya. Yes, I actually have, I'm currently just writing a small policy paper on this question. You know, what has actually been happening in the last 10 years since the adoption of the UN Guiding Principles. And I would say that the UN Guiding Principles did instigate sort of a trend towards more regulation, no? And then you can go look back and you know, this idea of we need better regulation of corporate entities that are acting transnationally, you know, that goes back to the 70s and it's never really been successful. And how do you grapple with this? So I think in general, you can say there is sort of this tendency, no? And I'm not one of those that would say, oh, mandatory human rights due diligence is the solution to everything. I do see the pitfalls clearly that you have indicated, especially in this question of obligation of means versus of results. I still think, I don't think that if, well, I mean, and I would say the question is not, well, one, it's not, of course, it's not only mandatory human rights due diligence that will solve things, but I think mandatory human rights due diligence can do one thing if it's what I would now call a comprehensive human rights due diligence. One that means it's not just fair enough to say, oh, I've done a little social audit and here's my, you know, corporate social responsibility policy paper from 10 years ago, and I've just put human rights due diligence in it, you know? So if you say, if you put in certain criteria of what a substantial risk analysis means, of what substantial, you know, a remediation plan means, yeah? So I think you can, and if it has a substantial reach and so on. So I think then that in combination with available tools like civil litigation or any other, I think it can create something. And I think what it can create, because if you look at the field of what law does in global economy, law organizes the ability of multinational corporations to have access to resources, natural resources and labor, and to secure the extraction of profits. And that's what is all organized through either international economic law, or it's organized through corporate law and through contract law. So it's clearly, you know, and I think there's in supply chains, there is no responsibility legally because it's all one contract after the other. And, you know, you have no responsibilities to your business partner, what they do with, you know, how they produce the good. So I do think this is at least one tool where you can say we bring back some sort of responsibility. Yeah, it's the first, and maybe not the best, but I do see it as one chance of saying, well, maybe you've organized all your change only through contract law and you bear no social responsibilities, like labor responsibilities, economic. But, you know, it's one way of pushing back to push back on this dynamic. Obviously, to solve this whole problem of what I would call, you know, organized irresponsibility, yeah, of course, it's just a little step. But I do feel like it's one of the tangible options we have. And I think the Unión Hidalgo case also showed there was no option. Well, at least now there's a court, right? So we can fight this. And obviously it's very open. You know, how the French courts will determine all of this and how they will interpret due diligence is also very open. And of course, that is a struggle. Well, but I would say it's a good struggle to fight now because, you know, it's at least for communities a very concrete way of where they can bring their struggle, as I said, back to Europe, you know.
Thank you, Miriam, and thank you, Professor Surya. I agree with the reflections that you gave us, and I think part of the success of this case is that we had been reflecting and planning as organizations and also with the community about how to use the law, no? And we know that the law at the national level and also at the international and the transnational level, it is not the tool that is going to resolve the structural problems that you already pointed. But what we are developing with this case and the strategy is the possibility to underline the capture of the state, including the capture of the judicial system at the domestic level, and if there are some alternatives to bring these reflections to the country where the matrix is. In this case, as we explained, EDF is a French corporation, and we are, with this law, having the possibility to open the discussion legally, the discussion about the responsibilities on violation of human rights of this French corporation. I also believe that this case is not going to probably to set the standard of what the corporate accountability. No, that is our ultimate goal. But we know, as you also pointed, how complex is the power relationships and the power dynamics that are involved in the model business, and also how the human rights narrative and discourse is also being captured, not by the corporations, no? And I think that is the challenge, but also the opportunity. These kind of cases and this kind of litigation present us and also the communities an opportunity to open new arguments, to prove new arguments, and to give content to what is due diligence and what is the responsibility of the governments, and also the responsibility of corporations, principally from the perspective of the communities. Because as you say, and you say it correctly, it is also a substantive issue, no? What means corporate capture of the state? What means due diligence? Everything is very ambiguous, and we are struggling with the concepts, even the concepts at the domestic level, and the concepts of the law of vigilance in French is very ambiguous, and proving in the litigation that the corporation committed all these violations, and proving, for example, the responsibility of the commercial partners at the local level that are the ones who are committing violations, and a joint liability between those commercial partners through the supply chain until the matrix, which is EDF. It is one of the challenge on the litigation, but it is an opportunity to push a better content of these discussions at the national level and also at the transnational level. And the other opportunity is, as was mentioned before, this case is it will sound a little bit weird that I am saying this, but it is a beautiful case because we are being able to prevent the major violation for this community, which is the dispossession of their land and their territory. And that already is a success for the community, because as you say, for them, the land is not a commodity. It is their life and it is their future, no? And it is a different meaning. We are talking about meanings, no? It is a different meaning, and only this possibility to exercise the collective power as community, pushing an economic power as EDF, pushing back EDF is already a success. And this case also demonstrate that the law could be thought and apply for litigators in a critical way and have results, no? Which is avoid violations of human rights in a context where powerful actors have all the possibilities and the communities have almost nothing, no? And I think it's really interesting what you bring to the table. It is part of our reflection, and I think it's the best approach to have. Living the we are not we are trying to be very clear also with the community, no, not create false expectations about the remediation that we can bring, or the litigation that we are going to do in France. That is also part of the reflection related to power dynamics. We are very clear about what we can achieve, but now they know that they can achieve justice because they were able to decide that this wind park is not going to evict us because this is our right to maintain our land, our territory, our culture, and our future. So thank you so much.
Great, thanks to both of you. And I think there's so much more to be said, and you really flagged essential questions to be discussed. But before returning to human rights due diligence more in general, I also want to put some questions to you specifically on the Unión Hidalgo EDF case. So one questioner asks whether you could explain the choice to focus on EDF and not the Mexican state. Would it not be easier to demand a suspension of the project on the basis that the permits the state has issues are not valid because there has not been free, prior, informed consent? And may I just add a couple more, so please do take note of them. That's more focusing on the proceedings in France. So one questioner asks whether in the first phase, as you were saying, you also hope to receive a sort of injunction. What are the limitations of civil liability for cases when abuse may not be easily quantifiable, such as with free, prior, informed consent? And another questioner asks whether the lawsuit in the French courts is based on the enforcement mechanism to compel the company to adapt its vigilance plan, or whether it's based on civil liability or potentially both. And maybe lastly for the moment, since EDF is a public company, would it be possible or feasible to argue that it has an obligation of result instead of an obligation of means? Any expectation of how the French courts may react to such an argument of it being a public company? Lots of questions. Alejandra, do you want to go first?
Annelien, are you reading the questions from the panel? From the
Yes, exactly. We just ordered them a little bit more to group them in 2 or 3 parts.
Okay, because I was trying to follow the questions. So I think I will respond some of the questions because I was already working in the response.
That's fine too.
Okay. Let me see. Related to Humberto's Cantu question, I'm just going to answer very quickly. He was asking about the Mexican law that is now in the Senate. And we believe that the law itself is a good step forward, but unfortunately it has begun wrong. There was no discussion with researchers, NGOs, and most importantly, indigenous communities and workers. Without this kind of support from those groups, it will be impossible to hold corporations accountable, even if the law passed. The objective is not to pass the law, but to pass a law that has legitimacy in where communities and workers are taken into consideration, so that then these communities and workers can take the law into their own hands to demand respect to their human rights. So that is our analysis until now. To this specific initiative, I am not aware if there are other initiatives already presented to the Senate, but the law that was presented, it is very weak, and it is not taking into consideration the minimums that are already set for what would be a better due diligence in national law in Mexico. We are also doing activities that you mentioned in Mexico, and we have demanded that the project is not constructed until a free and prior and informed consultation and consent is reached, but it has been difficult to access to justice in Mexico. And we think that human rights defenders must be creative and use every tool and strategy possible. Also related to the Danilo's question, we think that this case exemplifies that defending the rights of certain community has an impact not only in that community, but also in other communities. Human rights are ensured when we reach legal precedent, when we build spaces for participation, real participation of communities and decision-making. And extraterritorial litigation is not only desirable, but also needed to try to break a bit the imbalance of power that we already talk about that exists between the economic powers from the global north and communities in the global south. Related to the Robert's question, we believe that colonialism is a topic that is very clear in this case. I think that is why the focus to push for accountability for a French corporation in France is very important. And I also know that the European Center has a lot of work on this field as well. Colonial behavior has happened in every step of the case. And I mentioned EDF and the governments have disqualified the voice of the communities. In our experience, this possibility that now communities around the world have in bringing their cases to the French jurisdiction. Unión Hidalgo is one case, but we were also following other cases, for example, the Total case. It is not reinforcing the colonialism. It is an exercise of power that communities have. And in the case of Unión Hidalgo, this community is accompanied or is supported by a human rights organization, a Mexican human rights organization that was able to have the capacities to raise funds and also to have a very professional work in litigating the case at the national level, but also in thinking how to bring these cases to the French jurisdiction. But that was not only our thinking. That was also part of the conversations with the community, because the reflection that the community was why these French companies can come and decide what to do and what to say in our community about our territory, and why we don't have the possibility to go to their countries and talk about what we want. And that is the right that they have. And that is not reinforcing imperialism. It is shifting the power dynamics. But that happened after 8 years of legal strategy, but also supporting their own internal organization. It is complicated and it takes a lot of time. This case, it is not an improvisation. It is the result of more than 8 years of supporting the communities, thinking innovative, strategic litigation, doing corporate research, understanding the corporation, litigating the case at the national level, using the International Forum of Human Rights for these results. And I can assure you that it is more complicated to just say that we are going to save the communities. Part of our methodology is respecting the political agenda and agency of these communities in order to bring or to build different ways to remedy this and access to justice. Another question is the question of Ellen about the solution, if there are a solution as an acceptable solution for the building of this park. And it is an interesting question, principally because what in our experience, the consultation is used as only as an administrative requirement. It is not really a process that is guaranteeing the participation, the real participation of the community. We litigate also the violation of the consultation right in Mexico of this community. We won the case. The judge, federal judge, gave us a resolution which is obligating the Mexican government to implement the consultation with the highest criteria for respecting the right of free and previous consultation, and also the right of deciding related to if they want the project or not. And the implementation is always a challenge for this, for the determination if this kind of consultation is fulfilling all the requirements of not. So what is acceptable or not, it is part of what the community is trying to argue in this case. No, for them, it's not acceptable to build the park because building this park is going to close the possibility to keep growing as a community, because they have around their own community already more than 30 parks. And that is part of the complication. But I will leave it there. I think Miriam have more to say related to the questions.
Okay, thanks so much, Alejandra, and also for bringing it back to the community. And I think actually we'll probably also already make this our final round of comments because we are running out of time. We're supposed to end in 3 minutes. But I'll pass over to Miriam to also maybe get back to some of the questions which were posed on the litigation as such. And of course, also if you have any further comments on the structural questions of human rights due diligence, also very welcome.
I mean, there were a number of questions also to Surya, so I don't know.
Yes, I'll definitely hand over to Surya last.
So I will be very brief and concrete on mostly those, there were some jurisdictional and very legal questions. So we are not asking under the loi de vigilance, you can ask only in a second step for compensation of damages. We are not going there, but we are saying that we want the court to compel EDF to adapt their vigilance plan. And we are then also wanting to say that until this EDF has adopted their vigilance plan with accordance of the law, we want them to halt the project. So we are not asking for the civil damages, which I think is really also an advantage of this law, that you can go in this two-step process. And then, yes, this is a very good sort of idea to say, well, as EDF is also a majority held by the French state, its shares, that there's a heightened responsibility because also the French state has their own human rights obligations, which would also apply extraterritorially, at least to some extent. We have not yet argued this elaborately in the first brief, but we're in the very beginning. But this is definitely one of the routes that we do think, and you would also find, for example, in the UN guiding principles, some indications that state-owned companies potentially bear more responsibilities than just privately owned companies. I think I will leave it with this.
Great. Thanks a lot, Miriam. And back to you, Surya. And there have been quite a few questions picking up on what is realistic, what is idealistic, and how to actually make it better to overcome the challenges you outlined. So yes, let us know more.
Thank you for excellent questions. There are several questions that are kind of asking the same issue that I should address, and that is what should, let us say, a better or more ambitious mandatory human rights due diligence should look like, in my view. I think it should have several elements. First of all, there should be an obligation of result in some cases. If the due diligence is merely imposing an obligation of that you do A, B, C, I think in my view that is not enough. There should also be a possibility of strict liability in some cases. If you look at the environmental law jurisprudence in many jurisdictions, strict liability is already well established. So why cannot we apply it? And I think that is why we need to be creative. We should not lock our head in Pillar 2 of the UN Guiding Principles. Pillar 2 is the starting point. Pillar 2 is not the end. And I think that is my suggestion, first point. Second point is that access to remedy and corporate accountability is absolutely vital. Any legislation that is adopted in 2021 onwards, if you do not have access to remedy and corporate accountability built in, with due respect, that is not a desirable development in my view. We should not celebrate that. Because if any country would like to adopt a modern slavery legislation, what UK did several years back, and you don't learn lessons from it, and you enact that kind of a law in 2022, nothing to celebrate here. My apologies, nothing, there's nothing there. So access to remedy is absolutely vital. The third element is any such legislation should also draw some red lines. Let me give a couple of examples. Is it possible for a tobacco company to respect UN guiding principles? I'm asking this question to anyone. Think about it. Can tobacco company respect UN guiding principles? In my view, it cannot. So are there certain red lines? Can businesses who are operating in Xinjiang respect UN guiding principles? This is the question I'm asking. So are there situations, are there circumstances in which mandatory due diligence or due diligence will not allow you to respect human rights at all? So I think those are the red lines we should be aware of as well. And my last point is that we need to be aware that who is doing due diligence at what stage and how. What should be the role of the communities? Can we ask businesses to provide funding, an independent agency which is facilitating this impact assessment on the part of the communities, rather than businesses hiring these consultants who have a conflict of interest because they also want to get more deals from other companies, right? So I think we don't get me wrong, due diligence can work well, but I am getting increasingly worried that we are going in a wrong direction. And I don't want to be participating in a webinar 10 years from now talking about these difficulties. That's why I'm making these red flags now, that we critically make an assessment and go in the right direction. Thank you.
Thank you so much, Surya, and thank you also, Alejandra and Miriam, for a really great conversation on such timely questions. And I certainly hope that we're not going to repeat the same over again in 10 years, and that we find those creative solutions, which I think ECCHR and ProDESC surely want to push in through their work. And thank you, all three of you, for your work on these issues, on the cases you accompany and bring, and for your commitment with the human rights defenders on the ground, which is really, really essential. And yeah, I believe there is progress being made, but also agree that we need to be very careful to assess it and make sure we can steer it in the right direction where it is possible. And sometimes power relationships aren't easy. Before we close, I would also like to remind everyone of our next events, and there's actually quite a long list to share, and I'm sure we'll also be able to share them in our chat for you to follow up on. So tomorrow at this time, as part of our Bonavero Network series, the Oxford Children's Rights Network is organizing an event on single parent discrimination in the UK and its impact, with Ruth Talbot, the founder of the Single Parent Rights Campaign. This Friday, on the 19th of February, we can continue some of today's discussions in a roundtable co-organized by the Essex Business and Human Rights Project, the Oxford Business and Human Rights Network, and the Utrecht Center for Accountability and Liability Law, and a great panel of colleagues from Essex, Utrecht, and the Danish Institute for Human Rights, and our own Bonavero postdoctoral fellow, Katja Aristova, will discuss the implications of the recent litigation against Shell in both the UK and the Netherlands. And again, you can find the link in our chat. Next Monday afternoon, we'll have our last panel in our three-part series on the past and present of slavery, which will focus on modern slavery, and which will surely also touch upon some of the issues we discussed today. Speakers include the UK's Independent Anti-Slavery Commissioner, Dame Sarah Thornton, Professor Siddharth Kaura from the University of Nottingham, and Kate Garbers, the founder and former director of the charity Unseen. And our Bonavero discussion group next Tuesday on the 23rd of February, they will look forward to welcoming another member of our advisory council, Professor Christoph Haynes, Professor of Law at the University of Pretoria, and until last year, also a member of the UN Human Rights Committee. He will discuss the UN Human Rights Committee's General Comment number 37 on the right of peaceful assembly with Marko Milanovic, Professor of Public International Law at the University of Nottingham. So again, a very warm thank you to all our speakers and to everyone for your active participation. It really was a pleasure to chair this Bonavero discussion group, and we look forward to seeing you again at our next events. In the meantime, do keep well. Goodbye.
Bye. Thank you very much, everyone.